Hey, welcome to the barbecue. It's Thursday, May 5th. Happy Boys Day, everyone. Boys Day is a Japanese festival that I experienced living in Hawaii. It's been celebrated for over a millennium. Originally, it was celebrated in the houses of warriors. It honored boys' courage and determination. Tonight, we'll be celebrating some boys that have grown into men of great courage and determination. I'm Patricia Aiken, an average host with exceptional guests. Tonight, I want to first give a shout out to Jessica and Lindsay from National Stand By Me for Freedom. They came all the way from Colorado this weekend with children to participate in the rallies. The crews from St. George and Salt Lake, great meeting you folks. I also want to give a shout out to Doug Knowles for his steadfast support and to Dave McQuiston from Eastern Oregon. It's an honor to know all of you. The rally in Boise this Saturday was outstanding. If you didn't see the photos of that, you got to go online and see them. Thank you, everyone that participated in the rally. We have a special guest or two maybe going to call in tonight, and when we do, we'll give them the floor. In the meantime, I'm excited to welcome two remarkable men to the barbecue. There are no coincidences. When I saw the filled 3-inch binder labeled Bundy indictment when he came into the Henderson Gulag, I knew I had to find out more about him. Rudy Stanko's book, The Score, should be required reading for every patriot. Mr. Eustace Mullins wrote the endorsement on the back cover. That was enough for me. Rudy, welcome to the barbecue.
Yeah, glad to be here, Patricia.
Excellent. Thanks. The second time I bumped into Rudy, he kept saying our next guest's name and how important he could be to the Nevada and Oregon cases. Dr. Roger Roots is an attorney and a PhD, I believe, in sociology. If I ran the world, his book, The Conviction Factory, The Collapse of America's Criminal Courts, would be required reading before you could even apply to law school. Roger, thanks for joining with us tonight.
Well, thank you.
Okay. Well, I'm telling you, your book has been something between potato chips and crack cocaine on the addictiveness scale. It is just riveting. So
well,
this week I'll bring you up to speed. If you haven't heard, the Conviction Factory's Black Robe Sock Puppet ruled that a blind man in a wheelchair that has epilepsy and an undiagnosed skin problem that creates all these scabs on his hands, who can't find his way to the bathroom by himself, was a danger to the community because he used violent rhetoric. I say violence is violence and rhetoric is rhetoric. What do you gentlemen say?
Well, the history of governments worldwide is a history of accusing people who write dissenting things or criticize government. It's a history of accusing such people of being, committing treason, being terrorists, being violent against the state, plotting sedition. I mean, thousands and thousands of people have been executed and hanged over the years just for pamphleteering or writing statements that governments didn't appreciate. So, this is nothing new.
Yeah, silencing the dissonance. Rudy?
Well, I've seen this defendant in court there in Las Vegas when they had their hearing on the right to a speedy trial or whether it was a complex case. And this guy's pretty helpless, but obviously even that judge up there, which obviously she wasn't an article-free judge, and I find how these magistrates can really rule and make these important decisions to keep these people in jail when they're not an article-free judge. And that's one of my problems I have. None of these lawyers, which I call public pretenders, that are defending all the Bundys and all the other defendants, have filed one motion demanding an article-free judge. These magistrates shouldn't be the ones that are responsible for keeping these people in jail. And it was just kind of a carte blanche decision on her part, and there was not one of these public defenders objected to her decision and want an article-free judge. So you can see these defendants are grasshoppers in the toilet bowl, as I like to say. They have no defense.
What I thought was telling is when somebody was using their phone to take notes, he wasn't disturbing the court, but she called him by name, by first name, and reprimanded him like he was her son.
Yeah, right. Yeah, it's one big happy little click here. And the reason why I think these public pretenders don't want to file any documents protesting the actions of the judge up there is as they're a big fraternity, and they don't want to have a reputation of criticizing Her Majesty. And obviously, they ought to say right away that they ought to take her off the bench and demand an Article 3 judge. Not that an Article 3 judge might not be any better, but at least he's not going to be fired. And this particular magistrate is on a weekly salary. That's why they're called, a monthly or yearly salary. That's why they're called a magistrate. A judge is in there for life tenure. They can't fire him for regardless of what decisions he makes. So therefore, that means he might not be so much partial towards the government and might be an impartial judge.
Well, when this whole thing started in Oregon, right after it started, they reversed a famous case here in Nevada, the Wayne Hage case. It was a ruling by Judge Robert C. Jones, where he said it shocked the conscience of the court, and he gave a laundry list of felonies that he felt like the BLM agents had committed against the Hages. I thought it was a weak ruling at the time because it forced the Hages to sign the BLM contract, but it forced the BLM to give them their water rights back, which I think is ass backwards. But anyway, so now, and I was wondering what's up with that. There's no coincidence that they're doing it now. And now I know they were doing it to get rid of that precedent because they knew that they had this indictment coming out against Cliven and the other 18.
Yeah, I knew Wayne Hayes very personally. He helped me a lot. I had a 150,000 acre allotment up in the Grand Teton. I used to run 1,000 mama cows, and for some reason, somebody brought the Hages into Lander, Wyoming, to give a little seminar, and that's when I got acquainted with him. And I did follow through with his argument about my water rights. In fact, I was having all my cabins up there, and I was going to bring in dudes, and I was going to make all these old cabins livable where they didn't have running water on that principle of Hage. And then about that time, I get thrown in jail for having a felon in possession of firearms because I'm up there. I need my guns to shoot the grizzlies and the wolves. But that didn't make any difference to the federal government. So, I'm very familiar with Hage, but I really like Bundy's argument. And Bundy basically will say that he wants to go a step further. I believe Bundy's one of the first persons that I know of that brought up this Article 1, Clause 8, Section 17 of the Constitution that basically limits the federal government for property within the D.C. 10-mile square of Washington, D.C.
Yeah, I think that's a huge argument, but they still continue to treat us like a territory. Roger, let me ask you this: when they reversed the Hage case, that the flimsy argument they made was that because they found that the judge was biased against the government. That's like the judge works for the government. I mean, that's like saying the judge is biased against murderers and rapists.
Well, listen, 99% of all federal judges are biased in favor of the government. And by the way, judges, when they are being frank or in a private conversation, will even admit that they are biased in favor of the government. Almost all judges, maybe I shouldn't say that, a very high percentage of all people who become state or federal judges are former prosecutors. So they come up through the law. They learn the law from the prosecution perspective, and they are agents of the government. I mean, they see the law and they see the cases before them through the eyes and through the perspective of government. So the idea that there might have been one judge that they was accused of being biased against the government, it's almost preposterous. And by the way, if you look at the specifics of that claim, what had happened in that case is that the Hage Ranch had gone to a very special court. It's called the U.S. Court of Claims, the U.S. Court of Federal Claims, which is a very specialized court that deals only with monetary damages from the government. So if you have a monetary damage claim against the U.S. federal government, you can go to the U.S. Federal Court of Federal Claims, and it's a very specialized court in Washington. And the Hages had done that. They had literally done that. They had litigated their case for years, how they had been deprived of really being a profitable ranch in Nevada for years and years and years. And I believe they litigated that case for a decade, finally got a judgment, several $1 million judgment in their favor, saying that the government owed them millions of dollars. And what happened then, the government appealed and takes it over to the U.S. Ninth Circuit Court of Appeals, which is, it's good and bad, but it has a reputation of being, let's just say, liberal. And I mean that in
Marxist to the core. I'll say it, Marxist to the core.
Well, there's good and bad judges on it, and sometimes the word liberal can mean different things. But to me, the word liberal sometimes means a judge that will, be a little bit more protective of criminal defendants, perhaps. So the word, it depends on what you mean. Certainly, the word liberal, when it comes to property rights and business, is really horrible. And I think that's what the Ninth Circuit is known for in business and in economic kind of cases. They basically side with the regulatory mindset, and they overturned that $1 million judgment in favor of the Hages had a judgment that was going to pay them millions of dollars. The Ninth Circuit overturned it and said essentially that they didn't have a right to all of their water claims that their grandfather had perfected on what was called federal land.
Right. Well, it was only public land and where they had grazing rights. But that's another whole issue here. Both you gentlemen have been guests in the Crowbar Motel. And I need to ask how that experience has colored your outlook of America and the courts in America.
Go ahead, Rod.
I was going to say, there aren't many, one thing, we are living in a police state, and it's getting worse and worse. Our society, our country, our nation, we are going into, unfortunately, what most other societies in the world have been living in for years, which is we are going into a deep, dark police state.
Totalitarian regime.
Yeah, it's harder and harder for an individual to defeat the government in court. It's not supposed to be that way. We have this legal structure that descended from English common law that was, it was the adversarial process in which judges were supposed to be neutral. By the way, that's not true in most countries in the world. But the English system, which we inherited, which is a product of unbelievable tumult and riots on the streets for centuries, hangings, bitter civil wars, the English Civil War in the 1600s, all kinds of violence in the 1700s. All of our rights come from that English system that we inherited. And we're losing that because, ironically, the legal profession, which is the very profession that you would think has a duty to closely watch and take care of that these fundamental principles of the Bill of Rights are not violated, the legal profession has dropped the ball, and it's because so many lawyers cannot identify with people on the other side of the government. And I say that, as you point out, I'm a rare attorney. I actually spent 1.5 years of my life in federal prison on a gun charge 20 years ago. I'm an ex-convict. There aren't many lawyers like me in the world, and there should be. I'll just say one of the big problems in my eyes, there aren't enough convicted felons who are lawyers, and there aren't enough lawyers who are convicted felons, because the lawyers of the modern world in modern America overwhelmingly view the state as a source of comfort and warmth. And that's really the real problem with American law.
I agree. It's in a past show we played a clip from a show in the 1950s called Longines Chronograph. It was the Longines watchmakers. They had a very conservative, I'd call it a news magazine today, and they were interviewing a congressman from New York named Keating, not related to the savings and loan Keating, and this was in the 50s. And I remember he was on the Judicial Subcommittee investigating the Department of Justice. And they asked him very pointedly about midway through the interview, Don't you agree that in order for a totalitarian regime to take hold in the country, they have to begin with taking over the Department of Justice? And he chimed in right away. Oh, yes. And the police to control the interior. That's what they need to take over. I couldn't come up with a better explanation of how this has happened.
Yeah.
So Rudy, how is the time that you spent and being railroaded colored how you feel about this?
Well, basically, I think even I told Roger. Roger's a libertarian. He ran for the Libertarian Party in Montana as for the Senate, I believe. And I was a libertarian probably before Roger was out of high school, and I voted for Clark. I think it was back in the 70s, 80s, right around the 80s. And so I always had this ideology that we had too many laws and too many rules and regulations. I probably got more speeding tickets than anybody in the country. So I was always probably down on the police state right back then. But yeah, the old saying back when that was in the 80s, if you had enough money, you could get out of jail, or you could defeat the justice system if you got the right lawyers and if you had enough money. Well, of course, as time went on in the mid-'80s, I had meatpacking plants, and I had about 800 people employed with me, and I was slaughtering about 1,500 cows a day. So I was one of the largest meat packers in the United States, and I had a lot of money. I was making, some months I'd make $1 million a month. So I thought I had enough money. So there was a certain group of people wanted me out of business, and so they put me on national television. And of course, I had to hire the best attorneys I could. I thought they were. And I spent probably $1 million on my defense alone. And after I was convicted, and I still don't know what I'm convicted other than what I write in my book, guys. If somebody wants to know what I was convicted for, I said, read my book. And I don't think I really have an answer, because I don't even know why I was convicted other than the fact that I was vicariously liable because supposedly a dead cow got on the kill floor, and we were killing 800 cows a day on one, and I don't know how the cow got on there, but I'm vicariously liable because of it, so I get 6 years in prison. So the point that I'm getting at is I spent $1 million on lawyers, and they didn't file one motion for me to dismiss my count. I got flushed down the toilet, and I can see the same thing happen to the Bundys right now. None of these lawyers, they're public pretenders, are filing anything. You might get once in a while they'll file. I understand that Ryan Payne's lawyer filed a pretty good motion to dismiss. I haven't read it yet. But on the whole, none of these lawyers have filed anything for these guys, and they should be flooding the courts with documents just to preserve their appeal, because it's going to be very difficult for the Bundys and all the defendants to defend this at trial. And as I say, the federal government's got a 99% conviction rate. Most of these guys, most of the defendants will probably plead guilty and turn against the Bundys. That's just the scenario of cases. It just happens. Their attorney says, "Wait, you got to say this, and if you do this, I can get you 1 or 2 years. I think I can." They don't really know, because it's all up to the probation people and how they write up the pre-sentence report. And the judge will say that. They'll say, "Okay, Mr. Jones, you understand that I don't have to take this penalty or this plea bargain?" And all the defendants will say, "Yeah, Judge, I do." Now, if I was a defendant, I'd say, "Malarkey, Judge, you got to make this. This is a contract between me and the government. I'm going to make this plea, and you got to stick to it, whether you like it or not." And if
Oh,
you don't have
exactly. When they say, "Oh yeah, we'll take if you'll take a plea, we'll make sure you don't get any jail time," and then they come back after you've agreed to take the plea and say, "Oh, by the way, we don't know if we can guarantee you no jail time now."
Oh, absolutely. Judge will say that to the defendant. Say, "Now look at Mr. Jones here. You know I don't have to go by the plea." And most defendants say, "Yes, Your Honor, I understand that." And I just want to have the defendants be aware that don't let the judge say he can overturn the plea, because you tell him, "No, if this is not the deal, then I'm not making a plea."
That's right. Let me add to that. He's absolutely right, and this is a vital point that not many people know, and not even many lawyers know. All right, the judge at that moment will say, "Well, I don't have to agree to a plea agreement that's between you and the government or whatever. Do you understand that?" And the guy, just as Rudy just said, almost every defendant will say, "Oh, yeah, I understand that, Judge." Well, listen, if you say the opposite, which is, "No, Your Honor, my understanding is I've made an agreement, and if you, Your Honor, sentence me above that, then I have a right to appeal." And the judge is bluffing. The judge is bluffing. All right. It's true that they have the right, because they're two separate branches of government. They don't have to even read a plea agreement. That's partially true, but the truth is, and everybody knows, that the judge really doesn't want to go to trial. Nobody wants to go to trial. So the judge will, and he'll hem and haw, and he'll gripe and grumble, but the judge will ultimately say, "Oh, okay, I'll give you the sentence that you've agreed to." So it's one of those big bluffs that judges do.
Well, I think what shocked me in your book, Roger, was whereas a jury comes back with a non-guilty plea, that a judge will override that.
Oh my God! Listen, the case law is filled with cases where a jury, for example, a 10-count indictment, the jury might come back finding not guilty on 9 counts and guilty on one, what they believe is a minor count. This happens all the time. Drug cases, for example, where the jury wants to say, "Well, this guy's innocent, but we'll just give him a little slap on the wrist," and the jury will come in saying not guilty on everything, but guilty on one little thing, what we think is a little thing. Okay, at that point, the sentencing is in the judge's hands, all right? And at sentencing, the judge literally will conceptually reconvict the defendant of all the counts that the jury acquitted the defendant of. It's a scandal. It really is a scandal. It's been happening for years. Actually, the U.S. Supreme Court actually tried to do something about this problem in a case called U.S. v. Booker. They struck down the sentencing guidelines and said that the sentencing guidelines were just guidelines and not requirements, because the jury has to find any fact that can lead to a greater sentence has to be found by a jury. So it was a pretty good decision. But even after the U.S. v. Booker decision, which was written by Justice Scalia, the main opinion, even after that, it's been about 7-8 years since that case came down, and the judges are doing the same thing again. They're reconvicting, conceptually convicting defendants of crimes that juries acquitted them of.
Well, what drives me crazy about this is then we have the media, who are just the mouthpiece for this cabal that runs this country, the largest organized crime syndicate in the world. And they'll come out and say, "Oh, well, the court did find him, guilty," and stuff like there's anything going on with the court. How did they get to a 98% conviction rate?
Well,
is that because of the police situation?
Well, I'll tell you, I can show you the data. As counts are added, remember, like this Bundy case, for example, there are multiple defendants and multiple counts. And the more counts, the more likely they are to get a conviction on something, okay?
Right. They're just throwing it up against the wall to see what sticks.
Exactly. And statistically speaking, I could advise these guys, statistically, the chances of being acquitted of everything become almost nil once the government piles on so many counts and so many charges and so many defendants.
Right. That's why they call
really
it trumping
up. It's an uphill battle.
That's why it's called trumping up the charges, right?
Yep.
Exactly. These most of the men I've talked to so far aren't willing to take a plea. They want to get in front of a jury. Man, that was the defense attorney for that guy in the wheelchair this week. He said, "Oh, things go better in front of a jury than a judge." But he was resigned to the fact that was a predetermined thing, that he had no hope, and he was kind of weak in his presentation. He hit all the right points, but he didn't do it with any passion. And you brought out something in your book, that a passionate defense is now considered old-fashioned or out of favor with the courts.
Oh, listen, it's widely known. It's almost unwritten code in court that the judge will punish you if you defend your client too much. It's almost unwritten law. No, they will never say that, but you are punished if you take the charges to trial and don't plead guilty. And if you're found guilty, that judge will punish you. In fact, there was one judge, I forget who he was, I forget his name, but there's one judge quoted somewhere that said something like, hey, well, that defendant decided to take a little bit of my time, and I'm going to take some of his time. It's that much of a game. I mean, they punish you if you go to trial. You're supposed to plead guilty.
Rudy, you got anything to add to that?
Well, I'd like to say one thing about these juries. I've come to the conclusion that that's how we got out of common law, because the juries are supposed to really sentence the defendant in a true common law court. And all these juries are advisory juries. And so they've got away from common law. And, of course, that's where that's where all our rules and regulations and laws and statutory laws, it's just the opposite of common law. You can look that up in Black's Dictionary. I didn't learn that until about 4 or 5 years ago. But these juries basically are just advisory juries. And even if whatever verdict they come up with, it's still in the judge's hands. That's how some of these judges overturn their juries. And that's not the way our primary law and our founding fathers visualized our court system. The juries should be not only the ones that find the people guilty or not guilty, but if they do find them guilty, I think they should be in their hands, not the probation people and not the judge. And what the probation people do is write up a report and just to back up the judge, so then he's got a little documentation on how severe he can punish the defendant if the jury finds him guilty. So the jury, when they find you guilty, they have no idea what the sentence is going to be. And that's how our system really, I think, got corrupt. They are no longer the superior law of the land, as some people want to imply that the jury is supposed to be. They are nothing but advisory people for the judge and the judicial department and the executive branch.
Well, that brings me to my question about this, because, I have a friend. They had at least 2 grand juries, and they believed 3 before they could get an indictment. And even with as bad as the grand jury situation is these days, it took them 3 grand juries to indict this guy. What a kangaroo court he went through. But how have we gone in America from the original grand juries that were independent from the court? They were like the buffer area between the government and the people. How have we gone to the situation that has yielded the expression that a good prosecutor can get a grand jury to indict a ham sandwich?
Well, that's it. They're really not common law juries.
I've got a chapter in my book, The Conviction Factory, about this very topic. Originally, all through probably the 1600s at least, well, really probably going back to the 1200s, the Magna Carta period, all the way up to well into the 1800s, a prosecutor was barred from the grand jury process. A prosecutor could not even be present, okay? This has been completely overturned over time. Today, the grand jurors are sworn in by the judge. Then they go into an adjacent room in the courthouse, and the person that greets them is the prosecutor. And so this is the practice today, where the prosecutor is in the room with them, and he presents them, and of course I'm sure he's friendly and laughs, giggles, provides them with donuts and coffee. This is the prosecutor, and puts on the case. Well, I want you guys to indict this guy, and then the grand jurors go into a little deliberation room and vote. And of course, they vote to agree with the prosecution. In some years, 99% of the time.
It's unbelievable. Why the hell have a grand jury? I mean, it is a travesty what's going on.
Yeah, the real travesty is that the grand jurors don't know that their primary role and duty and purpose by constitutional design is to act as a check on the government. They don't know this, and they're not told this. The fact is that by constitutional design, the grand jurors are supposed to act as the almost the obstacle of the prosecution, and instead they end up sort of thinking that they are,
the rubber
parties
stamp
with the prosecution.
Yeah, they're just rubber stamping whatever the prosecutor wants. It's disgusting. It really is. And I look at this and I see, what do we see on television for dramas? Well, you have, lawyer shows, you have doctor shows, and cop shows. I mean, and they're all just programming the public to think that those are good systems, and they all stink.
Yeah.
So how do you get how would you get a decent grand jury? I'm looking, before we get into prosecutorial abuse and judicial misconduct, which we could probably talk about for the rest of the time, there was a couple of guys in Denver, I believe, that were handing out pamphlets explaining jury nullification. They were arrested and charged with jury tampering. Isn't that outrageous?
Yeah, I'm sort of
the legal advisor for the Fully Informed Jury Association. So he's defended and knows all the cases about this jury.
Well, I thought he would, because it came out of Montana with that thing. So Roger, I know that got overturned. That the judge dismissed it, but and I hope they sue the cops and whoever else was involved in that. Do you think there's going to be a lawsuit about that?
My understanding is there is a currently pending federal lawsuit. In fact, it's a lawsuit for injunction. I believe they have won an injunction at this time. The government is appealing, but they won an injunction stopping the police from arresting pamphleteers outside the courthouse. And let me just, if I could discuss this issue a little bit. The jury has the absolute right to acquit, okay? Absolute right to say not guilty, even if evidence of guilt is overwhelming. Even if the jury sees the defendant take the stand and admit and confess in open court under oath that he committed the offense, the jury still has the right to declare him not guilty. This is, this is a fundamental right to jury trial going back 300 years, okay?
Yeah, conscience.
However, the judge, exactly, jury nullification, all right? The judges hate jury nullification. They hate it. Prosecutors hate it, all right? They want the jurors to believe that they have to convict if the government proves its case beyond a reasonable doubt, and it's simply not true, all right?
Well, I brought that up at jury selection, and it was absolutely hilarious, because the judge, I was trying to keep my mouth shut and get on the jury for whoever the poor slob was that was sitting at the defense table, and trying to defend himself. I mean, I felt bad for him, and so, but the judge asked that juicy question: Will anybody here have a problem following my instructions to the jury? Well, I just couldn't help myself. I had to raise my hand, and I said, well, until I know what the law is that you're accusing this man of, I can't say I can't follow well, that led to a big McGilla, so I won't ever get called for jury selection again. But matter of fact, I can't even get a lawyer in Las Vegas to return my phone calls now. I'm blacklisted for some reason. So, yeah, well, jury nullification, it needs to be, people need to wake up, but they're the zombies that we have in our society. Jury selection. Let's talk about that. Rudy, were you tried before a jury, or was this all judicial?
Well, I've probably been indicted 10 times, and absolutely, I look at the Bundys will probably get some superseding indictments. So this original indictment is more than likely especially in Oregon, I predict there'll be another indictment. And so they get to start all over and get to let the clock go by. But I probably had more jury trials than most lawyers, because I'm pretty famous up in Montana area. Anytime I get a ticket, and if you get even a speeding ticket, you have a right to a jury trial. And you can try it in their common law court, where their judge doesn't have a lawyer's license, so you can get a man off the street sometimes at justice of the peace. But so coming back and asking your question, what was your question again, Patricia?
How were the juries when you were on trial? I've had friends on trial and they just completely gut the jurors and they end up with homeless people and Walmart clerks.
Well, yeah, yeah. Well, they seem to side with the government because I feel like most. And then another thing, and I don't want to sound like I'm a male chauvinist, but I do have women. I have about a 70% woman juries all the time, and so I get. And it seems to me that women are they obviously there's books saying women think different than men, and they do have a different outlook that they're more orientated towards regulation and government and security. So you're right off the bat, you're going to have primarily a female jury, especially in these lower courts and these county courts. It's always happening. I have 70, 80% women on the jury. So I don't have too many entrepreneurs and businessmen that are anti-regulation because most of them don't want to go on a jury and they can't afford to go to the jury for to get paid $30 a day because they got a business to run or they got to make a living. And so right off the bat, you're stuck with a partial jury that's for the government, I feel. And then even if I do have some men, again, I'm going to have school teachers that get paid for going to the jury because they can get off of their school teaching job. I have mostly government people sitting on the jury.
Oh.
So it's really not a cross section of the community, and I think that's going to be one of the issues up there in Portland, Oregon. And Roger, especially, won a case for me in the Eighth Circuit where we challenged venue. Now these people shouldn't be tried in Portland, Oregon, just like you read Roger's motion for to inspect the grand jury. The same thing applies to the petit jury, and also venue. So I think that's a good issue if any of these lawyers ever file it, that they should be tried in a U.S. county court, probably in Pendleton, where you get more a rural atmosphere.
Right. That's what they did. That's what they did to the Hammonds. They actually didn't. They actually brought jurors in from 2 hours away that knew nothing about ranching or country life or anything like that, and they weren't allowed to put on to even explain why the fires were set, that these were prescribed burns and backfire. I mean, it was just a total, travesty what went on there. But, you brought up an interesting point about women that I'd like to follow up on. And Rudy, I bet you know what I'm going to bring up about this. Stanley Milgram, that study. I'm kind of appalled by how many women are involved in both of these cases, either as judges, as prosecutors, and magistrate judges and all that, because the Milgram study, the Milgram study showed that women were more apt to follow a authority figure. They were mock torturing someone with electrodes and telling the women to turn it up. Well, professional men would go, no way, I'm not doing that. No way. But the women would turn it up to complete torture level if the authority figure told them to. So I believe that's part of what's going on here in these cases.
Oh yeah, absolutely. I'm this is the first time I ever bring this up because it's not politically correct saying that women think different than men. But if you study it, and one of my famous philosophers is Alfred Rosenberg. He was a lead. He was in charge of education in Germany during Hitler's regime. And he basically did say, once you start having women being leaders, being your judges and being your cops, that shows the decay of the country. Because women basically are historically been on our housekeepers, keeping the family together, taking care of the family. That's basically been their job, where the man was out there leading. And these books that I've been reading show that the mind's different when it comes to arithmetic and figuring calculations. You don't see too many women in the engineering field compared now in the lawyer field or the cop field or the judge field. So that's just my unpolitically correct philosophy, and I'm standing by it.
I'm standing by it with you, Roger. Without Rudy, Roger, how do you feel about it? Women on the jury and how influence?
It's a fascinating topic, and I tell you what, it hasn't been studied enough by scholars because there's something there. Let me just say, we all know that it's only been a few years that women have even been allowed to serve on juries in some states. It's only been 50, 60 years. Look at it that way. How strange is this? I mean, it's completely different than...
I want to throw this out. The Negro got the vote before the woman.
Yeah. It's you just think about how we're in a time period where a lot of fundamentals have changed so much. I can tell you, I was in Dallas, Texas, I believe, and I was looking at this huge plaque in front of this old courthouse there, and it says this was the place where the first woman on a Texas jury in Texas history ever served on a jury. First woman on a Texas jury. And guess what the year was? I could be wrong, but I think it was something like 1952 or something. Very recently. Just think about this immense change where women, and as you point out, and by the way, I don't think I've seen the data that well, but you mentioned 70% female juries. I think that's actually fairly common around and there are several reasons for that, because in the jury selection process, some people professionally cannot be on juries. Cops generally are thrown off automatically for cause.
Yeah.
So a cop generally is automatically off the jury. Most cops are males.
And ministers, anybody that's a licensed minister, you're out.
Right. And there's several professions which are disproportionately male, and they're not on the jury. Okay. So then there are the business people and the people who get excuses not to come to jury service. Disproportionately male. All right. So they're off. And so what you end up with in a lot of places are, juries that are disproportionately female today, in today's courtroom. Again, this isn't how it was 60, 70 years ago. It's the complete opposite. So the impact of this is still not completely known. I don't think it's been studied enough.
Right. Well, our friend Mark Emery, I want to read your comment he's making to me in Skype. He says the judge neuters the jury by saying the jury is only to determine the facts and the judge will determine the law. And he says that's wrong. And he agrees that jury selection is the key to the case, the most important element in the entire process. He says, and when he was on trial, he made each juror on his trial promise him that they wouldn't allow pressure to sway them if they're the only holdout, among other things. And 2 women held out for me and gave me a hung jury.
I'll be darned.
Wow.
Yeah, the opposite is true. I mean, we all know women who are very, very, very strong and very, have a very good spine to them. So, you get both anecdotes.
I would say Mark's situation is probably very rare. Very rare.
Yeah.
So, gentlemen,
I will say this.
Okay.
Let me just say one thing. The modern juries are so scared. They're scared. And let me just tell you, it's deliberately done. They come in. Keep in mind, most jurors don't know anything about the law. They don't know really about how it works. And they're made to take this oath at the beginning, right before the trial. And they raise their hand, and the judge says, "Do you swear under oath?" And in the oath changes. It's not always the same in every state or every county, but a lot of them say things such as, "Do you swear that you, under penalty of law, that you will abide by the instructions of a judge?" And of course, this is completely unconstitutional. The jury, by constitutional design, is supposed to have independence from the judge. All right. But anyway, so they take this oath, and then after the trial's over, then the judge warns them about the oath that they took, and suggests that they can be punished. And it's not true. It's just a lie.
Oh my gosh, that shocks me.
It's amazing. It's our system is so it's tragic in the way that it's been flipped on its head.
I mean, it's Bolshevik America. What the grand juries were supposed to do, they're doing the exact opposite now. And so, do you have hope? You're involved with the fully informed jury movement and stuff. Do either of you have hope that the common law grand jury thing can get a foothold?
With regard to the grand jury thing, that is an uphill battle. I think that it actually is going to take a major movement maybe congressmen, maybe, I mean, it's Supreme Court justices, maybe, before it really gets any traction. With regard to the jury nullification stuff, I can tell you that there are some cases that may go up to the U.S. Supreme Court, which, the U.S. Supreme Court has not really had any big rulings on this kind of stuff. They haven't really come down hard. There've been a lot of split decisions and some sort of weak, lots of long court rulings with different, dissenting and
Maybe it is, maybe it isn't.
opinions and things. Yeah, and so the law hasn't been clear enough, I guess, which has allowed these prosecutors to threaten guys outside the courthouse who are pamphleteering, threaten them with jury tampering for handing pamphlets to jurors that say, hey, did you know you have the right to acquit? And I think there is a chance that this is going to, in our lifetime, it's going to end up being in the U.S. Supreme Court. And I think that I can't imagine that the situation can get any worse than it is right now. So I do have hope.
I hate it when people say that. It's kind of like famous last words. So we've got a couple of minutes before the break, Rudy. Tell me what common law grand juries. You're common law, Rudy. Tell me.
Well, the common law grand. Well, that's the essence that we've got away from common law, because the jury, common law is just the opposite of equity law, which is statutory law. And here the judge tells the jury that they're just to judge the facts and not the law, and this is equity court. So again, the jury is nothing but a pawn of the judge. They're not a true common law jury. They're not free to make their own decisions. They're bound by statutory law. So it's not a common law jury. So any way you look at it, the judicial system has taken charge of the whole justice system, and all the jury is out there is just to confirm the judge's decision. It's not a common law jury. It doesn't. So we're a long ways from it. And maybe, like Roger says, there might be some hope of a Supreme Court decision coming down, but I don't have much hope with the Supreme Court justices that we have on the court right now, even though Scalia was what you might call a conservative, and he was hard against, he was probably an equity advocate of the judicial system, even though he ruled in favor of Booker that the jury has to decide any of the penalties. Now, that was a good decision. But again, the jury is nothing but a pawn of the judge right now, this system. And even though the Supreme Court might come in with a good decision, look how they eroded Booker. And that's the Booker was the case where they said the jury had to decide all the law or the penalty, and it wasn't up to the judge. And that's really gone by the wayside.
Right. And so, but common law grand juries, things like National Liberty Alliance and these other groups that are getting out there, like the man that was up in Harney County with the protesters, and that's one thing I don't get. You burn down a city like Ferguson or Baltimore, and it's get called a protest, and you stand up for the Constitution, and you're called armed, militia, armed. Whatever they called them. I mean, just terrible.
Yeah.
Yeah, it's
it's funny.
Go ahead.
If you look up, during the 1960s, there was a group of Black Panthers that actually went into the California state capitol during legislative session and took over the legislature with weapons. I mean, literally, and there are photographs of this. Black Panthers,
Eric Holder did an armed takeover at Columbia of the student union because they wanted it to be renamed after Malcolm X or somebody. Didn't hurt his career.
Yeah, in the California case, they were initially charged with a felony, and then ultimately, I think the case is settled out. They all pled guilty to minor misdemeanors. It's amazing. And then you look at these Bundy defendants. My God, they're looking at decades in prison. It's amazing.
Yeah, and these are all the men that I know from this, all good family men. Some of them were only there for 4 hours, and you know what they were doing? They were armed. They had a rifle over their shoulder because for self-protection, and they were helping the state troopers direct traffic.
Oh, there was one guy who allegedly did nothing more than ride a horse around up in the Oregon case, just for riding a horse, and he's under the same indictment that everybody else is.
It's that totalitarian regime trying to get rid of their dissidents. And the situation is that there's so much at stake here. We've got music. We'll be back after the break, everybody. Stay with us.
You are the eventuality of an anomaly which, despite my sincerest efforts, I have been unable to eliminate from what is otherwise a harmony of mathematical precision, which has led you inexorably here.
You haven't answered my question.
The Matrix is older than you know. As you are undoubtedly gathering, the anomaly is systemic, creating fluctuations in even the most simplistic equation.
Choice. The problem is choice.
Right here at Revolution Radio, freedomslips.com. Be here Wednesday evening at 8 p.m. Eastern Time for Private Eye Matrix Revealed with Monique Lassonde.
Listen in on Mondays, 8 Eastern Time on Revolution Radio for Journeys with JP. With a variety of guests, each giving their perspective on their journey into the now. Join me and my guests Mondays, 8 p.m. Eastern on Revolution Radio Studio B.
Every Tuesday evening on Revolution Radio at freedomslips.com, we present our goddess spiritual warrior, Kathy Bilski.
I command. I call to the architect of the universe's divine creators and ask for permission to quantum leap the world in all life forms on all planes and dimensions, seen and unseen, connected with planet Earth, to let us go beyond our known potential into the greatest unknown golden age the universes and worlds and all planets have ever experienced.
Kathy teaches the spiritual truth so that you may create a better life and be able to make positive changes for yourself and for the planet. She helps us remember that we are not powerless, but very creative spiritual beings having an Earth experience. Time to quantum leap into the age of divine enlightenment and let Kathy provide you with the tools of knowledge you need to awaken spiritually. That's the Quantum Leap Show. Let Light Unite every Tuesday at 10 p.m. Eastern on Revolution Radio Studio B.
Enter into a world unseen on Raven Star's Witching Hour. You will encounter eclectic topics from the realm of spirit brought into our matrix of truth. With your host, the Solaris Blue Raven. Solaris will bring you an array of unique guests covering topics from ghostly spirits to amazing anomalies, covert technology, UFOs, and shadowy global events.
And that's right here at Revolution Radio, freedomslips.com, Saturdays, midnight till 2 a.m. Eastern Time. Revolution Radio, where information never sleeps.
Let the magic rise.
Did you ever feel that things were not quite right? That everything was just ever so slightly askew?
Do you have, to paraphrase Morpheus, a splinter in your mind?
If you're interested in hearing the latest information about UFOs, the paranormal,
ancient cultures and structures,
monatomic elements,
longevity,
fantastic discoveries in science,
downloaded to your brain,
then tune into us. Hi, I'm Dave.
And I'm Mackie.
And we are Shiny Side Out, Sundays 2 to 4 a.m. Eastern. See you then.
Revolution Radio, freedomslips.com. You don't need to expect us. We're already here. The opinions expressed on this radio station, its programs, and its website by the hosts, guests, and call-in listeners or chatters are solely the opinions of the original source who expressed them. They do not necessarily represent the opinions of Revolution Radio and freedomslips.com, its staff, or affiliates. You're listening to Revolution Radio, freedomslips.com, 100% listener-supported radio, and now we return you to your host.
to serve it back in for the show. Thanks for your call. Talk to you later. Bye. Okay, there we go. Okay, I think we're back. This is our Sacred Cow Barbecue on Freedom Slips Revolution Radio. I'm Patricia Aiken, and it's my immense pleasure to have Rudy Stanko and Dr. Roger Roots on the show tonight discussing they are two amazing law dogs. Rudy got his legal education the hard way, and Roger at least got to go to school for it a little bit easier. But they both have just an amazing look. That they're both Americans and believe that this totalitarian regime that we're facing in this country, this complete Bolshevik nightmare that has come over America, needs to stop. And I feel, gentlemen, that the Bundy cases, both of them, and the Finicum case are going to be watershed issues. Do you agree that they're that important, Roger?
It's interesting because I regard these cases as petty. In terms of the allegations are so petty. And I can't believe, but as you say, they're watershed only because the government is making these huge deals out of them. Mm-hmm. But the underlying alleged facts really are petty. You look at recent American history, the Weather Underground. There were groups in America that were blowing up federal buildings. I mean, my God, Black Panthers. There were, and just in the last 30 years. And then you look at current U.S. District of Oregon, U.S. District of Nevada. These claims involving nothing more than, standing there with a gun and having a protest about federal, trespassing, federal, even if there is a disagreement over federal land, over land policy. I mean, these are such petty cases. Not a single shot was fired except by the government against the American people.
Right, and that's what one of the attorneys said. He says he just got on the case, and he said this just looks like a glorified trespass case. And there is no trespassing in the Oregon case. The doors were open. They left the keys. They lured them down there. There were obviously infiltrators that want. Where's the trespass? There isn't any.
Yeah, I'll tell you. And you know what? I really sympathize with some of these poor guys who went there and, honestly, they felt like they were, taking a constitutional stand, and some of them probably were a little nervous. Well, they probably, thinking, well, maybe I could face a trespassing charge or something. Yeah. And they're looking at these federal felony indictments. It really is. It's tragic. It's terrible.
Yeah, when you have a 24-year-old like Jake Ryan or something like that. I mean, but his mother made a great point. He said if more Americans would stand up, this would stop.
Yeah, the government has gotten so it's much more powerful than it used to be. The listeners should read up about the big FBI shootouts with. Ma Barker and the Bonnie and Clyde, that period in the 20s and 30s and 40s, mm-hmm. When the FBI was just sort of getting started, they would lose shootouts to the American people. Like they would be outgunned at that time. And today, they're so used to being so ensconced in security and power and overwhelming force, helicopters, machine guns. The government we're living under at this point is not anything remotely like intended under the founding documents of the country. So, yeah, it might be a watershed. These might be watershed cases, but if they are, it's not because of their underlying facts.
No, it's not because of the facts. It's because to shut down the government from these illegal prosecutions and the complete lawlessness that the government is exhibiting nowadays. So, Rudy. Let's talk about the bill of particulars that you spent 4 days on. This is about the Nevada case, correct?
Yeah, it sure is. Yeah, I just concentrated on the Nevada indictment. I knew Roger was up in Oregon, and he had the Oregon indictment under his belt. And of course, Roger went to Bend, Oregon, there, and got some affidavits for
Ryan
Bundy. And so I concentrated, and I spent 4 days because I told Roger, I said, this indictment in Nevada is really complicated. and obviously there's a lot of double jeopardy issues. There's a lot of gun motions for dismissing for guns that they're really not citing the person who was aimed at with the gun, or whether the guns. Then we have it right. There's certain guns that are exempt from federal law if the gun is older than 1893, at what you call an antique. And then there's certain clauses in the statutes that say possibly that shotguns and hunting guns are not under federal jurisdiction. The Congress put that in there because they really wanted to restrict the federal government, but the judges and the prosecutor ignore all these clauses. So we have to know what type of gun this is. This is the first thing. And the next thing is, in order for the federal government to get jurisdiction on any of these guns, they have to cross interstate. And if they don't know what model the guns are, then that kind of throws those particular charges out. So there's a lot of research that needs to go into this. So basically, my bill of particulars asks, when did these charges occur? How did they occur? And also, who are the people? And what are the make and the model and the years of the firearms supposedly that were brandished? And that's how they can wrap these charges. And I feel that they could run some of these charges consecutively, but most of them would be concurrent. That means they overlap because they happen at the same time. So I outlined the dates when these particular charges happen, and what charges and what charges they're quoting under the statutes. But primarily, I want to know what age of the guns are, did they travel in interstate commerce, and who were they pointed at? And I think any defendant needs to know this in order to defend their case. And most of them are all charged with brandishing firearms. And of course, the federal law states that brandishing is pretty broad. In fact, you're just carrying a gun. That means you're brandishing a gun. But I think that's an unconstitutional statute. That needs to get filed, that you can have a gun on you and still not be brandishing it. So you have to challenge that statute. And the reason you want to challenge it, in case the judges, and these judges probably dismiss all these motions that you file, you got appealable issues, right, and you never know when you're going to hit a jackpot. Now, Roger and I have been pretty fortunate. I think we win probably 40% of our appeals that we file. And, of course, I say Roger wins them because he's the writer, and I always say I'm the fighter. But that's primarily what my bill of particulars is all about, and it needs to get filed because they need to ask these questions, and they can't defend it until the questions are answered. And so I distributed it to Clyde Bundy, and of course he said he's got to take it to his lawyer. Oh, I talked to Clyde's lawyer about it, and he said, well, yeah, it's pretty good, but these judges never rule on them. Well, that doesn't matter. Get the damn thing filed.
Yeah, that's how I feel, because you're setting up the appeal at that point. Even if they don't, you're setting up the appeal. You want to have all this in the record, right?
It's a constitutional right to know the nature and the cause of the accusation. That's part of the game. Even though they admit they understand the indictment, nobody does. I don't understand.
Oh no, none of the men said they understood it. They said, "Do you understand the charges?" And they all said no. Good for them.
Oh, they all did that. Did they say that there in Nevada when they got arraigned? Huh?
Yeah, absolutely. And Cliven was great. He said when they asked him for his plea, he says, "Well, I'd be happy to give you a plea if you'll first demonstrate to me how you have jurisdiction over me."
Yeah, I seen that. I read that. Yeah. So, well, that's great. Well, at least they start. Now they got to follow up with the bill of particulars because they'll sweep that under the rug because you know what the judge says. Well, we're going to plead you not guilty. So the judge takes it in his hand and it kind of gets swept under the rug now. Mm-hmm. But at least they made their point. But they have to follow up now with the bill of particulars and demand this before they go to trial, because if they don't get these answers, I don't see how they can defend the case.
Right. And so I agree, and I think these are true. And is it just because there's 19 of them that there's a communication issue? The man the other day, and I talked with him afterwards, and he seemed all right. But I mean, he's sitting there, and he says to the feds, "I'd rather be watching a basketball game right now."
Yeah, that's typical. I mean, they pretend like they have their interest of their client in their heart, but they really don't.
Oh no, this is just another day at the office for him.
Yeah, right.
He doesn't understand that these men's freedom is in jeopardy if they don't do something. They got a lawyer up here. So I want to, let's talk about this brandish thing, because that's, well, and there's one other word that I know the feds are going to use, but let's talk about brandishing. I don't believe brandishing means that you're carrying a firearm. Brandishing, it's got to be that you got to wave it around and point it at somebody. Am I wrong?
Well, I'll read you what it says, all right?
Okay.
I'll read you what statute. I'll read it verbatim here. For purposes of this section, which is 18 U.S.C. 924 CD4, the term brandish means, with respect to a firearm, to display all or part of the firearm, or otherwise make the presence of the firearm known to another person in order to intimidate that person, regardless of whether the firearm is directly visible to that person. That's what their definition.
Wow.
Well, wait a minute. So that would mean that everybody that open carries is brandishing.
Exactly. It's a total violation of the Second Amendment in District versus Heller. That's the famous Second Amendment.
Let me just say, I mean, just think about the word bear arms in the Second Amendment. The Second Amendment says that the right of the people to keep and bear arms shall not be infringed. How similar is the word bear to the word brandish? It's very similar. So, I mean, on the one hand, you've got a constitutional provision that says you have a right to do this, and on the other hand, there's a statute that says, well, it's a crime to do this. It's amazing.
Well, these statutes aren't laws. They're codes and statutes that have been given the force of law, and that's how, in my opinion, this whole Talmudic system that we have of injustice got taken over.
Yeah,
and you have these. I had a woman that's running for Congress and she loves to say, "Oh yes, well we're lawmakers and we're going to make." We don't need more laws. We need less law repealers.
Put it in the hands of the jury. Let the jury decide the law again. We're back to the common law.
Well, it seems to me a lot of those. The indictment is filled with this claim that, they're brandishing a firearm in a crime of violence. Okay, well, they're basically stacking inference upon inference upon inference. The claim by the government is that there were people that had firearms visible, and therefore these federal bureaucrats supposedly were too scared to load some cows onto a trailer, and that constitutes an act of armed robbery.
Well, no,
crime of violence.
But here's the thing. That the feds had already agreed to give the cattle back before anybody ever moved from the protest area over to the overpass and the wash. They had already agreed to release the cattle. So they weren't intimidating anyone. That's ridiculous.
Now, here's another thing that needs to get brought out, and I brought it out in my bill of particulars. I want to know exactly how many cattle they are, because if you read the indictment or some clauses, it's like $3 million worth of cattle. Now, they'll use this figure, the probation people will use the $3 million figure if the Bundys get convicted of anything. And basically, when you look at the sentencing guidelines, they go by the dollar amount and how many dollars are involved in these cattle, then that increases their years of imprisonment.
Well, they're going to have to subtract how many cattle the feds killed.
Yeah, exactly. I mean, all these questions need to be asked before they go to trial, so it doesn't just rely on the probation people's sentencing report.
Yeah, so they're going to have to get the contracts, because these men were under contract, and one of the snipers in one of the helicopters said, they were told it was going to be Waco. Well, why is it that the government gets to do terroristic threatening, threaten a man with 7 children and a pregnant wife with Waco, and that's not violent rhetoric? That's not terroristic threatening? I don't get it.
Yeah.
It's pretty.
I sometimes say it won't be long before the American people will be made to bow to federal workers. And after we are made to bow, it won't be long before we're made to kneel. I mean, that's where we're going in this country.
Well, and so that's what my friend's husband says: stand up and be counted, or lay down and be mounted. I mean, this is what it's coming to. Is America is going to stand up? Do we have any hope? Is it? I don't even think we're at the 3% yet. I don't think so. But I don't think it's going to take a huge uprising. But they are gearing up with the technology now. There was a videotape of a reporter some kind of government employee, law enforcement guy, was showing off this armored vehicle, and she said, "Well, I can see that maybe in the streets of Iraq, but America? Well, what's this for?" And she says, and the guy replied clear as day, "Oh, well, there are a lot of constitutionalists out there that have a lot of guns and ammunition." They're tipping their hand. Yeah. Listen, everybody, you're listening to Sacred Cow Barbecue. This is our Revolution Radio, freedomslips.com. We are listener and volunteer supported, and I'm so grateful for my guest tonight. But I want to ask you to help us, run over to freedomslips.com, make a donation, get the archives. They're only $5 a night. You can listen to all these shows. Buy something cool, this amazing seed packets and things like that. Help support the station. If everybody figured out $2 a month for listening, we'd never have to make these appeals. And so we appreciate all the listeners and volunteers that make this, and everybody tonight's a volunteer. So we're talking with Rudy Stanko, author of The Score. You got to read this. And also Dr. Roger Roots, author of The Conviction Factory. I mean, I haven't been able to call it court ever since I started reading your book, Roger. I mean, it totally is. So I really, what else is on the bill of particulars, Rudy?
Well, I say too, if I was in contact with Clive, my first step would be to sue the brand people and sue the federal government for taking his cattle. First of all, if you think about this is all open range. So who's responsible for fencing this property? And all these cattle were strays. Now, if the federal government doesn't want Bundy's cattle on their property, they better fence it.
Well, exactly. Nevada's a fence-out state, but the feds are claiming the trespass because they're saying it was federal land. But that's where it all comes back to Article 1, Section 8, Clause 17. And so let's talk about that for a minute, because what the feds are trying to argue is that they acquired the land. And that is the wrong term, because acquire, according to Black's Law Dictionary, can mean that it was purchased for money, or that was acquired by, it was received by some other method. But no, the Constitution says purchased with money. They have to purchase it, and they never have. That's why they own 85%, of the state. A big bunch all over the West is completely controlled, as you both know.
Well, yeah. Now, here's the question I think that's got to be asked. Obviously, if you read these cases that Bundy's been filing in the court, they all claim that the United States acquired this land under the Treaty of
Guadalupe Hidalgo.
Hidalgo, yeah. And now, okay, so fine, they acquired the land under the treaty, but then Nevada comes into the Union. Now, if Nevada's land, which is 90% federal, why did they make the boundaries clearly in the state of Nevada, where the boundary lines, they should have just limited to Las Vegas and Reno, because that's about the only land that's privately owned in the state of Nevada. So Nevada really wasn't, they shouldn't have had the state boundaries, if you understand what I mean, because I'm going back to the Northwest Ordinance that every state that comes in the Union should come on the equal footing of the original 13 colonies according to the Northwest Territory and any states after that.
Exactly.
I think that's probably the argument of most people, but now I'm thinking, well, if Nevada became a state in about, 1869, somewhere around there?
Right.
Why did they have all these public lands? And I don't think any of these public lands, or I call them the security on the national federal debt, I don't don't call they're privately owned. That's pure communism when the United States owns all this land. If that's not communism, I don't know what definition of communism when they own so much land in the world.
No. In Article 1, Section 8, Clause 17 is very clear that they can only have control of those lands while the state, before it's a state, as it's a territory. And that's been the Bundy's gripe all along, that the feds treat us like it's a territory. For instance, where they put up that First Amendment area, and it was fenced off. If you want to say anything, you got to go get in the First Amendment area. And everyone's going like, are you kidding me, Jack? This whole country's a First Amendment area. But they're treating us still like a territory. And I think it goes back to the Reconstruction Acts of 1867. I sent a letter to the Congressional Research Institute, Congressional Research Service, ask them if the Reconstruction Acts of 1867 had ever been ended or repealed. Took them 8 weeks to respond, and they sent back a page and a half, single space, and it basically said, look it up yourself. They're not even admitting to it now. That's how they're getting away with still treating us as territories, in my opinion. And the Buck Act and the War Powers Act and all that. The Constitution was suspended. And when the American people wake up and realize that, I think we'll get it back. But
this why I'm really interested in the case, because that's the heart of the Constitution, is that the federal government's not supposed to own any property except for dockyards and 10 square miles of Washington, D.C., unless they get the consent of the state legislatures, which they never do.
Right, and they've never bought it.
No, they never. So really, it's I don't know what they like to call it, public lands, even though it's Bureau of Land Management and the National Forest Service. Obviously, I still say that's pure communism when the United States owns property.
And it wouldn't be so bad if they weren't the Bureau of Land Mismanagement. But the land is all there's 4 times as many range fires now as there ever was before, since the BLM has been trying to manage the horses and all that kind. I mean, it's horrible. They are horrible managers. It has nothing to do with managing the land and everything with locking it away from the people.
I really think the Federal Reserve wants people off there and kind of regulate this as their own private domain. That's basically, they want to keep the enterprises and the economic values of the property away from private ownership. That's obviously why they're trying to curtail grazing rights. They certainly were doing that up in my grazing rights when I was in Teton. I could see the writing on the wall there.
Right, and it's all about these the minerals under the soil and the water rights. Harry Reid owns 3 parcels around the Bundy Ranch, and the BLM owns another.
Really? Harry Reid owns some land around there, does he?
Oh, I'll send you the maps. You'll see it. That's what this is all about. And they have to start depositioning people for this, because that was brought up right after the raid, that he owns them and he's behind it, as if you don't know. And that's why he was threatening Carol Bundy. Oh, now that the Bundy men are in jail, we're going to come get those cattle.
So how much land does Harry Reid own?
Oh, the big parcels. I don't know the acreage amount, but big parcels all around the ranch, plus the BLM. So, and they want it. That's why they were moving the desert tortoises from this other place down, where he had this Chinese deal going for solar energy and stuff. I mean, it's corrupt as the day is long. Just think, like the thing in Harney County. Lazaro Esanaro has done a phenomenal job showing the corruption there. I mean, it goes all the way to Hillary Clinton, Uranium One. They already had the Hammonds sold. The property sold.
What type of affidavit did you find up in Harney County? What was the general?
Well, I'll tell you, I interviewed a number of witnesses. Basically, they were all very consistent. What the press reported as an armed takeover was a complete illusion. It did not happen. There was no armed takeover. There never was a time when anyone was barred from entering or exiting. Nobody ever stopped anyone from coming in including public officials, including actual, BLM and U.S. Fish and Wildlife. They were coming in.
They were invited. The FBI was begged to come and meet with them face to face.
And the witnesses I spoke to all said about the same thing. They felt very comfortable. There was no tension. There was no intimidation going on. So, I mean, that to me, that in itself just sort of blows the allegations of the government wide open. I mean, the government has made claims just that are not true. And then there are many other factors. Maybe I shouldn't get into too many details, but
Well, I heard from Tom Davis this week that Les Zaitz actually went ballistic this week. He went to Glenn Palmer's office, the Sheriff Palmer over in Grant County, and he went to his office and asked for him. And when they said he wasn't in, he just went insane, just threw a big fit. There weren't any deputies around, and they had to call the bailiff from the court to come and get him out of the building. I mean, this thing is falling apart. It's pretty
Davis?
Interesting.
Who's Davis?
Oh, Tom Davis. He owns High Desert Rough Stock up there. Some people know him as Tall Tom, rodeo guy. He's been very involved in this in the investigation. He has I think you probably were at his house, Roger. He he's a
rancher.
He's a rancher
in that county.
And they do him and an investigative journalist named Renee Powers do a blog site called The Cowboy and the Lady, where they're investigating this whole thing. And they've brought up a bunch of stuff. Another man by the name of Lazaro Esanaro, who's kind of new to all this, but he worked with Senator Ted Stevens and stuff on a case of his own. And so he knows his way around research, and he's dug up. There's not even 2 degrees of separation between everyone. And here we have Judge Grasty. He found out that he actually owns a house in Sun Valley, Idaho. That's pretty high dollar.
Wow.
Yeah.
Interesting.
Yeah. Oh, yeah. We've got a ton of research on this.
Yeah, I was going to say another aspect. There were, get this, in the Harney County, Oregon, so-called armed takeover. There were protesters and demonstrators who came onto the what's called the Malheur Wildlife Refuge and were insulting Ammon Bundy and the whole crowd there, insulting them, calling them names, and there never was a time when there was any violence. Nobody stopped them. Nobody said, "Get the hell out of here." I mean, how much of an armed takeover is it if your enemies and your opponents are able to come up to your face and call you names, and you don't? I mean, you don't even. I mean, this is how preposterous the case is.
Well, there was one night when a bunch of drunks came down. I'm sure they were paid to come down, had a little scuffle with the guy on guard duty, but that was it. I mean, the rest of the time it was an open house. You walked in and they fed you. I mean, they had so much beef coming from the ranchers that they had to put it out in the snowbanks to keep it cold.
Yeah, and another aspect, that area is a hunting mecca in which the town is very familiar. Nobody in that town is intimidated by strangers coming in with rifles because it happens every single year in hunting season. It's just it's a hunting mecca for birds and everything else. And so the government's claim that the town people were just scared to death of these outsiders and these guys coming in with guns into their county. It's just preposterous.
It's totally preposterous. But Karl Marx's favorite maxim is accuse others of what you do. So if there was any intimidation, it was the fact that the FBI was staging out of the school, that they have all these Apache helicopters and Black Hawk helicopters and took over the airport, had armored vehicles. There's the intimidation. They've been going around and rousting people out of their vehicles, searching them. And then just for intimidation, they would drive the car 100 yards forward after they were done searching it and make the person walk to it just to humiliate them.
Mm-hmm.
Yeah, it's unbelievable what's going on in that town. And it's because there's so much money this is not only about the money, about the uranium, it's about the Federal Reserve. This could take the whole situation down if all this corruption's exposed, and they know it. That's my take on it. So, but I don't think they have a case, but that's not going to stop them. And
well, it's all about. Remember, it's all about narratives. The government has created a narrative, and they point to one thing or another and say, "Well, here's what was happening," and the media just absolutely ran with their narrative.
Well, that's because the media is just
was fundamentally false.
And that's the thing I enjoyed about that was it told me who the a so-called alternative media really is. It told you the real people from the shills. Whoever ran with that narrative, I go, oh, I always wondered about you. So, Rudy, were you following this while it was going on?
You know what, the Oregon situation?
Yeah.
Yeah, definitely. In fact, I kind of was a financial man behind Roger. I bought his airplane tickets out there so he could go out and do some investigation. And so, yeah, I definitely got all my information from Roger, basically, asked him what really is going on. And so that's why Roger kind of concentrated on the Oregon deal, and I kind of concentrated on breaking down the Nevada indictment.
Well, good. That seems like a good division of labor.
That's how we kind of split up our time.
Well, I'm really seeing you folks being involved here, officially. What do you think are they going to be able to deny Clayman?
Are they going to be able to survive?
Yeah, they're going to be able to knock Clayman on the case?
Well, let me just say, every defendant has an absolute constitutional right to the lawyer of his choice, all right? The Constitution in the Sixth Amendment says you have a right to counsel. That doesn't mean you have to take the counsel that is government approved or that the judge wants you to take. So Cliven Bundy says he wants Larry Clayman as counsel, and so Larry Clayman has submitted a form. He's not a Nevada licensed lawyer. He's licensed in other jurisdictions, and he has a Nevada licensed law firm that is vouching and signing his paperwork for him. And the judge thus far has said no, he's not fit to come into Nevada in the case. My hunch is that will ultimately be overturned because I think the Ninth Circuit has some case law that's very favorable on that. That's my hunch.
Yeah, I understand that cases have been forfeited on that and overturned because they didn't allow the defendant to have their counsel of choice. And it clearly they don't want Clayman because he has that quaint little notion that nobody's above the law.
Yeah.
Yeah,
another. Go ahead, Rudy.
Well, obviously that's up to Clyde Bundy to make his choice, but I'm finding it kind of difficult that they don't want Roger on the scene when I'm willing to subsidize Roger and all his research effort. They keep saying they're short of money, they need money. Well, I'm saying I'll give a real legal scholar here, whatever his retaining fees are just to go out there, but I want you to agree that Roger was going to be on there as a pro hoc VJ. If that means that at least Roger will have some input on the case and not just be a research person in the background. And obviously I can't see why, if they're really serious about claiming defendant Bundy, why don't they interlocutory appeal it right now to the Ninth Circuit? That's the first thing I would do if I was really sincere about beating these guys and giving them a fight. So I question why Hansen didn't say, well, let's just appeal it. And I'm sure that I think the Ninth Circuit, there's case law to support that Bundy has a right to have Clayman be his attorney.
Right, and I don't understand why somebody of Roger's stature, isn't welcomed with open arms.
Right, yeah, I think, well, maybe Hansen wants all the publicity. I noticed he was kind of around the camera a little bit, but I mean, if I was really looking for the interest of my defendant or my client, I definitely would take all the lawyer help I could, whether it requires putting in a little motion to the court asking them to accept my help.
Well, apparently what I talked with Mrs. Bundy earlier today, and she had talked with them, and they were making it. Well, we wanted to make sure that he's on the same page with us. They go, he's a constitutionalist. He's conservative. What, And I don't know why they're hemming and hawing. I really don't.
Yeah, well, yeah, there's something fishy going on there. I can't figure it all out, but there's some type of politics going on there.
Yep, it sure is.
Right.
So, cruel and unusual punishment. Cliven Bundy is still in medical solitary. It's over 80 days now. Ryan Bundy, and I think that they're really scared of him because he's named himself a pro se and what have you. They're keeping him out of the law library. They're keeping him in segregation. I mean, that's for what? For having an extra towel and an extra shirt.
Well, Roger, we're going to have to work on that a little bit. I always say if Clyde would accept me as his assistant to counsel, I think I could get him out of lockdown. I really do. And you need to file a lawsuit. There's no doubt in my mind. You got to sue him and file for an injunctive relief. I just got a lot of case law that supports that pleading. And I think, but if they're not going to file, they're going to stay in lockdown. So it's somewhat their own fault by not making their lawyers demand that they're not be punished and they're only pretrial detainees. There's so much case law that pretrial detainees can't be punished like convicted prisoners.
No, it's
they
insane.
should be out in open confinement. They shouldn't be in solitary confinement. But the only way you're going to get that through is to sue them. I'm telling you that. And maybe we better get that worded. I didn't know Ryan Bundy was in solitary confinement. That didn't.
Yes, and when they brought him down here to Nevada, they put him back in solitary here for what he done, what they accused him of in an extra towel. And I think he had a conversation with the chaplain. The chaplain said the police can shoot anyone they want at any time, and Ryan disagreed with that.
Well, Roger, next time you talk to Ryan, if you have any communication, mention that I want to sue him, and I will draw up the lawsuit for him. That's my game anyway. I've probably sued more prison wardens than anybody in the United States. So,
okay, well, here I got another one for you. The men in Pahrump at this private facility in Pahrump, which is owned by Dick Cheney, by the way, I understand. They're having carbon monoxide problems. They've got these generators, and the smokestacks aren't tall enough, and the carbon monoxide's coming into the people I talked to. There were at least 3 areas that they were getting poisoned. Men that came in with absolutely no health problems now have breathing issues and pain issues and all that nausea and stuff because of this carbon monoxide. I want those men moved.
Okay, well, yeah, or I'll file a lawsuit. That's the only way you're going to do it.
My friend, who's actually a pro se litigant on his own case, has started notices and stuff to them. And so I actually sent that to the other prisoners so they could do the same thing and get that rolling.
Well, I think you've seen my lawsuit that I filed against the Portland jail because they returned some of my mail from Ryan Bundy. I think I mailed that to you.
Yeah, it was some real good kick assets, I'll tell you.
Yeah, and that will get their attention. That's the only thing. I think that does more, gets more of the warden's attention than publicity to some degree. Or phone calls from celebrities, put it that way. So I firmly believe I had a lot of calls when I was in prison, and it didn't do a hell of a lot of good. But when I filed lawsuits, they either changed their system or they moved me. Obviously I got the diesel therapy for doing it, but I got the satisfaction that they paid attention to my injunctions.
Right. So that's an interesting point that, we've got to start suing them. And so it's just really frustrating to me not to get people returning phone calls when I'm offering them, free legal help like Roger, and they won't call me back.
Right.
Well, so, and I just want to say something about the original Bundy case. When they lost, they actually went to the Ninth Circuit to lose. They planned to lose, but they wanted to go to the Supreme Court. And when I assume that the corruption in Nevada, everybody that said they would be what do they call that, amicus curiae or something, friend of the court, everybody declined. Everybody that promised them before, oh yeah, if you do this, we'll help you with this. Everyone declined. They were gotten to.
Wow. Who was their lawyer?
Well,
was Hanson the lawyer to the Ninth Circuit too?
No, I don't know who represented them there. I bet we could probably look that up.
Sometimes it's tough to get, sometimes it's tough to get lawyers to follow up. Some of them get busy, and a lot of this stuff happens really fast. I mean, it really does. And, a lawyer might get an email saying, hey, we want you to file a brief in 4 days, and they just don't have the time. So,
see, that's what they're doing to Mike Arnold. He was down here for the arraignment, and what they did for Ammon, and what they did, the Judge Brown knew that, and so she said that she needed something in 90 minutes for him to file, knowing that he was down here in Nevada and needed it filed on the Oregon case. So we think it's really unjust, and there's no way these men can get a fair trial when they're trying to defend themselves in two suits. How do you feel about that, Roger?
Well, I can tell you, it's very almost unprecedented. It's something. It's on new. You could call it a new plowed earth, practically. It's stuff that I'm not even familiar with. There have been many cases, for example, involving the mafia, where an accusation, the government will accuse a mafia individual of doing something in one case in New York, and then also, maybe having a hand in some other stuff in Illinois or something. But I'm not familiar of another case where they're taking people from one U.S. district court that's 1,000 miles away from another one, flying them back and forth for arraignment and other proceedings, and then flying them back. And then there's the speedy trial clock that is ticking in both jurisdictions. It's very, very unusual.
Yeah, and I think they want to make it as miserable as possible. I don't know what it was like when you gentlemen went to court. Well, you were guests at the motel, but what they do with these men in Pahrump is they get them up at 3:30 in the morning, give them a crappy breakfast at 4, shackle them by 5, and then put them in the van, and they're up here in Nevada by 6:30 or 7, and they make them wait until 3 o'clock in the afternoon for their hearing, and then get them back to back to Pahrump, and they have 2 bologna sandwiches all day. And if they're not back by a certain time, like 6:45, then they have to wait till 8 o'clock after the count is done. I mean, can you imagine what that's going to be like with a trial? No, these men have to be moved out of there.
Well, I can tell you that these guys really should not be detained. They need to be out so they can defend themselves. Because, listen, I can show you. I read, newspaper stories all the time of murder, first-degree murder defendants who are given bail. They're given the opportunity. Sometimes the bail is set very high, $1 million, for example, where they can't actually raise the money. But nonetheless, it's absolutely it's a violation of the Eighth Amendment.
Sure, murderers and rapists get out on bail. These are good family men. They're destroying their businesses.
Yep, all the time. And it's just they cannot defend themselves in this state.
No,
they just cannot defend themselves from a jail cell like this.
No, and the interesting thing is that when they were in their pretrial detention hearings, that they were or release hearings, they were telling them that if they let them out, they were making a stipulation that they couldn't talk with their friends.
Yeah, it's amazing.
That's ridiculous.
I mean,
they need to be able to put their heads together on a defense here.
It's the most fundamental right when you're accused of an accusation to be able to, investigate, to dig into the evidence, to meet witnesses, to actually build up your defense. And these guys are being absolutely deprived.
I know it's shocking that they can be this blatant about it, but it's Bolshevik. It's Bolshevik America. I mean, this is the Gulag, no doubt about it. And actually, Harry Reid, I've heard from someone, an elected official, that Harry Reid gave the order, put these men in the worst facilities you can find and treat them like crap. That was the order.
Why would Harry Reid write an order like that? I don't understand it.
Oh, because he's the vendetta. This is all his vindictiveness. because he wants that land. He owns the rest of the land around the Bundy Ranch. They want that land for something. It's where the Virgin River runs through. They want the water. They want this. He owns a big parcel. He paid a lot for it, like $700,000 for the parcel to the south of the ranch. And so you've got to read this whole thing. Ryan actually talks about it in the videos that we made with him the summer after the standoff. And there's been other people that I've talked to about this and how corrupt he is. And so his fingerprints are all over this. He has it in for the Bundys. He's mad that he didn't get the land that he wanted when he wanted it. And and just say that they keep putting out that lie that they owe $1 million.
He's starved to death out there unless there's something underneath that land that I don't know about. But I know he certainly couldn't be a cowboy, because that's a pretty you have to have a little experience to survive in that industry.
Oh no, there's mineral rights, and the water running through there is very valuable.
Yeah, obviously that's true.
Mm-hmm.
Yeah, that's pretty desert type country out there. I don't see how those cattle stay in such good shape. I was kind of marveled at the condition of the cattle, so that the grass must have some kick in it, or some protein, as they say. And then obviously it's a certain breed of cattle that can survive out in that desert. These Angus cattle we raise up here in northwestern part of the states couldn't survive in that desert heat. I know that.
No, and they in the summer you'll see them laying down like by the river, like they're having a picnic, or they're up in the mountains and stuff to cool off.
Right.
Yeah, it's pretty amazing, and the treatment these men have gotten. Like Mel Bundy, when he was arrested for no reason, he was beaten up, chained to a wall for 40 hours. I mean, they literally, his wife said, beat the crap out of him. He vomited on himself, urinated on himself because they wouldn't let him use the bathroom for 40 hours. And then when they did feed him, they threw an orange and a piece of stale bread on the floor and said, "Here, eat that."
Yeah.
These men have been abused.
Right. Well, yeah. I mean, quit yapping about it. File lawsuits. That's what I did. I understand. I was in the same situation.
Yeah. Well, I don't have standing, and these folks have not even known anyone in prison, much less been in prison.
I agree. I understand that, but I'm trying to get them to contact me, and
I know. I'm with you, Rudy. I'm trying hard to. I make calls every day about this. So maybe some other folks send some emails, post some stuff on Facebook. Right. Roger Roos and Rudy Stanko need to be on this case if these men are going to get any kind of a fair shot.
There we go. Get rid of that cruel and unusual punishment clause of the 8th Amendment. That's what you call Bivens versus 6 unknown narcotics agents. The Supreme Court ruled that you could sue the government officials under the Constitution clauses of the United States Constitution, the clauses of the United States.
Right. So that's what a Bivens tort is. Is that what you're telling me?
Yeah. That would be a constitutional tort because of cruel and unusual punishment.
And so tell me again, who was Bivens?
Pardon?
Who was Bivens? Why was it named after this man?
I think the narcotics agent broke into Bivens' house without a warrant. He took some property and he filed a lawsuit against him for damages.
Well, that's what they feel like in the Finicum that night where Lavoy Finicum was killed, that they didn't have any warrant, they didn't have any probable cause, and that's why it took them 5 hours after they shot Lavoy, after they started this thing, to get a judge out of bed to sign date some warrants and things. It's corrupt.
Interesting.
Yeah.
I should say, there's a set of statutes in the U.S. Code, Section 1983. I think it's 28 U.S.C. Section 1983, and sections of 1981 and other sections that they're called the Civil Rights Acts, where you can sue in federal court state government officials.
Yes.
All right. So then the Bivens case sort of arose because, well, there's this, on the one hand, you can under those civil rights statutes, which have been on the books for 100 years, you could sue state government officials, but there was nothing on the law books, at least in the U.S. Code, that at that time allowed you to sue federal officials. And so Bivens was a case, sort of a landmark case, went up to the U.S. Supreme Court, and they ruled that, in fact, you don't need a statute. You can actually just cite the Fourth Amendment itself. They violated the Fourth Amendment right to freedom from unreasonable searches and seizures, and that itself is, the Bivens case stands for the proposition that you can sue in federal court federal agents who violate the Constitution.
But, our experience is that the agents hide behind their agency. So this Bivens tort situation will take away their agency and get to them as an individual.
Well, listen, the courts have perfected all of these obstacles. A big one is qualified immunity. These government officials will claim that they are immune from suit, or at least if they're not totally immune, they're qualified immune. They're immune from the reasonable scope of stuff that they are allowed to do on their job, and so they can't be sued for that. And the courts basically have bent over backwards for the government over the years, and so it is very difficult. But you almost have to prove a knowing violation, that the officers knew they were breaking the law. And usually when you can show that, especially with an email or where they said something like that, then you got a case.
Good. Well, the feds are trying to make up that all the Bundy supporters are violent, and so we're a danger. And so that's why they have to have protective orders about what they release. And, it makes you wonder if they're going to file a protective order so they don't have to answer, this bill of particulars or some other interrogatories that you file. Oh, it puts our agents, puts our attorneys in danger.
Yeah, and keep in mind, when they make that claim that they don't have to give the names of for example, the officers, it also allows, over time, the courts have bent over backwards in these kinds of cases for the government, and it has developed that a lot of federal FBI agents have just gotten used to this kind of stuff, and so they invent fake informants. Literally, on search warrant applications, they will just invent a fake informant and say, this person who I won't name because the courts allow me not to name this person, he said this. And then, you come to find out there no such person exists.
All right, everybody, we're coming up on the end of the hour. I've got to tell you, you must get a copy of The Conviction Factory. Roger, what's the best place to order a copy of your book?
Well, you just go to Amazon. Amazon's the easiest place.
Amazon's
go to Amazon.
And you have to.
My
and you
name,
might as
Roger
well.
Roots, or the title.
Right. Okay. Roger Roots or the title. Excellent. The Conviction Factory. And you might as well, if you're going to order one, you might as well get free shipping and order two. Can we get this at Amazon too, Rudy? The Score?
I think so. I'm not for sure, but if not, you can get it from my place at Post Office Box 509, Gordon, Nebraska.
Excellent.
69430.
Well, folks, I told you these were law giants tonight. Thank you so much, gentlemen. We've appreciated it.
Listening to Revolution